Part 1, request for District Judge Lawrence O'Neal to intercede. Third status report, request for financial and legal assistance, cure to complaint errors, request review for Fresno Superior Court judge misconduct and or informational order. Brief intro. Plaintiff filed original complaint on February 9, 2011, accompanied by a motion to proceed on 3/4/2011 from Magistrate Judge Michael Shane, assigned to District Judge O'Neal. Then on 4/1/11, the court order staying the case pending resolution of the criminal proceedings. Court, please note, there will be no resolution after being arrested so maliciously. It is my intent to get competent counsel, deem the police report fabricated, and get this case dismissed. In that stay order, the court alleged my complaint rambling and misunderstood my complaint. For example, on line 9, page 2 of the stay order states, plaintiff's complaint was 4 pages of rambling alleging against everyone associated with the August 2nd, 2010 arrest and subsequent prosecution. Attached to the complaint are copies of various documents, and it appears to be police and court records. The best the court can discern, plaintiff alleged the following. On August 2nd, 2010, defendant Kazarin performed the traffic stop on a plaintiff's vehicle because of a light out. After running plaintiff's license information through the system, police dispatch informed Kazarin that his license was suspended. Plaintiff got out of his vehicle. Kazarin placed plaintiff in handcuffs and performed a search of his person. Kazarin did not find any drugs on plaintiff's body. Kazarin arrested plaintiff for driving on a suspended license and undertook to have plaintiff's car towed. Defendant Gabehart performed an inventory search of plaintiff's car and prepared for it to be towed to the impound lot. Gabehart found a white rock-like substance on the floorboard of the car and concluded it was rock cocaine. Plaintiff alleged that Gabehart planted the drugs in plaintiff's car. Plaintiff was arrested for possession of rock cocaine. It is unclear whether plaintiff's requested to get out of his vehicle or Kazarin asked him to step out of the vehicle. Plaintiff's allegations are not consistent with the point. Plaintiff submitted a video proper to the arrest. The court considered the video for evidence but has not viewed it. When I read this rambling, I went back and reread the original complaint, seeing the errors and the wording and misspellings. So then I attempted to cure the complaint by filing an amended complaint, which was logged into records on 12/29/2011 and stricken on 1/9/2012. Within that stricken order, I was ordered to file a third status report by 1/25/2012. With that, I would like to bring to the court's attention, I misread the date on the order. I was sick under the weather and confused the date with the 27th. Thus, the third status report was filed 2 days late. In short, when I got sick, I lost track. Having said that, I have attached the amended complaint to the back of this report, attempting to cure the rambling and the errors of the first original complaint, if need be for retraction, more so to ensure a clear understanding with the court of the allegations. Because the courts confused my allegations, the records need to be corrected. For example, the court reads, it is unclear whether plaintiff requested to get out of the vehicle or Kazarin asked him to step out of the vehicle. Plaintiff alleged allegations are not consistent on this point. Note, I never said this. I stated I was handcuffed while in the car without probable cause. So then, the First Amendment complaint was filed to clear the misunderstanding. Nevertheless, it was stricken, and I was ordered to file this third status report by the 25th of 2012. Next, and safety first, I am requesting financial assistance so that I can move to a different location. I do not feel safe after being arrested so maliciously. Plus more, I do not want to see Officer Gebhardt or Kazarin with a gun anywhere close to me, including Fresno Superior Courthouse, for any prelim. Remind of what these two Magic Tactical Team Task Force team cops did to me. First, the task force made a third window brake light stop. Let's get real. My light was not out. The next lie was the report stated I was being uncooperative. Another lie that I can deem by videotape. The next lie was the report stated I was sweating profusely like I was high. But they did not test me. Another lie. Next, neither officer did a field test on the alleged drugs. They didn't do a field test on the alleged drugs because I was taken straight to jail. Next, the officers didn't book any drugs into police evidence locker in my presence because I was taken straight to jail. Next, officers did not get the drug results back until the next day after I posted bond. See drug report dates. How can a drug report date supersede a bail bond date? Plus more, the officers that handcuffed me while still in the car, the officer that searched me and put me in the back of the police car, and the officer that booked me into county jail did not write the police report. No, not to mention the video that will deem the police report fabricated, a felony when the police report are to be signed under the penalty of perjury. The penalty of perjury. If the court can see, 1, the drug result report superseding the bail bond date, the tactical magic team making a traffic stop, third, a police report alleging I was high but not testing me, compared with the model case about fabrication of a police report, link attached below. Drag this link to view a 3-minute video CBS News report, as well as comparing the police report with the 36 admission questions for both officers. Request for admissions. These are the admissions questions defendants would like both officers to answer. Note, a more seasoned attorney could ask better questions, but these should deem the police report fabricated. Once the DA's office and the court can get the response from both of these officers, I will ask the court for a conference and show the videotape of these officers lying and fabricating the police report. Note, these admissions questions apply to the officers Gebhardt and Karzan and are to be answered under the penalty of perjury, to be used in both the criminal proceedings as well as the federal proceedings. The questions should speak for themselves.